Hussain.
Thank you very much for that. When we took the break, I was about to go into Suraj, but I'll leave that for a moment and sort of tie up the loose ends regarding my preliminary comments. Okay? Is it working? Yeah, sure. So, the point I wish to make is that Parliament is entitled to determine the breadth of review that is afforded to the courts. In a sense, it determines the jurisdiction of the courts relative to its constitutional obligations relating to the judicial review of statute. We have here an argument that the Sedition Act should be tested as against Section 1 of the Constitution. In an environment where the Constitution is the supreme law of the land, and where the constitutional provisions have to be read together, and Section 1 cannot be untethered from the rest of the Constitution. Now, if the argument of my learned friends were accepted, I wish, if I may, to refer to the case of Chandler number 2, which at electronic bundle 2034 at F, where Lord Hodge stated as follows.
Sorry, just give me the page again, please.
Page 2034.
2034.
2034.
34.
Yeah.
No.
At F. (2034) at F. Yeah. It's at Roman 7. It reads as follows. Given priority to a modification clause in the 1976 Act, it deals with the Act to start with, over the savings law.
Sorry, which was the modification clause in the 1976 Act? What's
That's Section 4 of the Constitution Act.
Right. So not the Constitution itself?
Not the Constitution itself. Would in large measure destroy the effect of the Savings Clause, which is part of the supreme law of the state and which reserves to the legislature power to determine whether and if how to change any existing law to conform with the fundamental rights articulated in the 1976 Constitution. So let's put aside the issue of Section 4 of the Constitution Act, to which the Constitution is a schedule, and deal with the issue of both 1 and 6 being the supreme law of the land, and an environment in which the Parliament has reserved unto itself the power to change pre-1976 laws, that is, existing laws, and that is virtually a no entry point of the legislature, because the powers in respect of judicial review to existing law is restricted and is confined to laws passed after 1976. And it gives effect then to the living tree doctrine, where it evolves over a period of time. Secondly, on that basis, Section 1 cannot be given priority over Sections 4 to 14 of the Constitution, and especially Sections 4 and 5 that give effect to fundamental rights. And that is a matter which, in its own deliberate judgment, the legislature has created the Constitution in those terms, where Section 1 is given its own life. It is not duplicated in 4 and 5, and I will deal with that as part of my presentation later on. And they have to be read together And you can't give Section 1 a prominence over Section 6, nor can't you give it a prominence over 4 and 5. Nor should you read it in such a way so as to create interpretation problems, and therefore avoid as much as possible the issue of duplication, because in 4, there's an express right dealing with commentary on political affairs, the press, and freedom of expression. And therefore, it's not duplicated in 1, because the effect of that is, does 1 take priority over 4 and 5? To what extent do you have freedom of expression and the freedom to express your political views and freedom of the press? To what extent and how far those rights go? And thirdly, there's no legislative guidance in 1 as to what is the extent of the rights that are created in 1, except a democratic state and the separation of powers argument. Now, I think that can be best illustrated by the reference I made before to the question of lex specialis and the judgment of the Supreme Court in Day and the Cayman Islands, which Lord Sales delivered. And that is in the authorities, and that is in the supplemental bundle of authorities filed by the respondent. It's at page 74.
Is that the respondent's further supplemental?
Further supplemental, yes.
Further supplemental, thank you.
Yeah. Now, the first thing I have to do is locate the specific provision, and then locate the general provision, and determine whether there's an inconsistency, and urge upon my lords to accept the proposition in D that the specific should override the general, except in very exceptional cases. So the facts of D are well known to our court. There was a specific provision in the Cayman Islands Constitution, Article 14, that dealt with marriage between a man and a woman. And there were other provisions in the Constitution of the Cayman Islands that dealt with the issue of family and private life, as the case could be. And the argument arose as to the fact of whether there was a lex specialis in respect of the issue of marriage between a man and wife, or whether under the law in respect of a private and family life, that could override that provision, or alternatively could be read compatibly with it. And the question of compatibility is important. Now, applying that to this particular case, it is our respectful submission that Section 6 is a provision that is lex specialis. Section 4 and 5 also create rights, those are lex specialis. And Section 1 is a generalized provision. And it can't be that a specific provision in Section 6 that creates an existing law and says it from judicial review is now trumped by a generalized provision in Section 1. Where in circumstances the very rights being contended for are in 4 or 5. So this is even a deeper case, and reference is made in that judgment to the argument of Dana Rose, I believe, at page 85, where that point is explored in some detail. And I'm not going to read it, my lord, it's well known, at paragraph 30, and the board said, look, we have to accept that argument because 14.1 is a lex specialis, as the case may be, and therefore that is accepted. Now, on that same vein, on the issue of lex specialis, might I just digress for a moment and take you to the same judgment, the judgment of the supplemental bundles, and a number of propositions that are set out at page at paragraph, is it paragraph, yes, at page 86, and it's an extract from Lord Hoffman in Matadine against Pontoon at paragraph 34. I'm not going to read the entire paragraphs, my Lord, but I'm going to just select sentences that are reproduced, well, the entire extract is reproduced in D. And forgive me for not reading Matadine and Pontoon. And these are the points made in that extract. The first thing, it is worth emphasizing that the question is one of the construction of the language of the section, and in this case, the construction of the Constitution. The second issue is what I call the context interpretation. And Lord Hoffman says this is because every utterance must be construed in its proper context, taking into account the historical background and the purpose for which the utterance was made. The third principle is the background of the Constitution is an attempt at a particular moment in history to lay down an enduring scheme of government in accordance with certain moral and political values. Interpretation must take these factors into account. And the fourth issue reproduces the often cited quotation from Sir Sidney Kentridge when he presided in Zuma, in the South African Supreme Court. If the language used by the lawgiver is ignored in favor of a general resort to values, the result is not interpretation or delineation, as I put it, but one of divination, as the case may be. Now, taking those factors into consideration, what the appellants are contending for is an expansion of the right of judicial review of legislation that carries beyond the boundaries established by the Constitution, read as a whole, particularly sections 1 to 14. It is not, with respect, a principal position that a court might be entitled to take into consideration because of a number of reasons. One reason, as I mentioned before, is where do you delineate the exact boundary of a democratic state without the guidance of the legislature in respect of what rights are captured by Section 1 and what rights are not captured by Section 1. It violates a structural issue in the Constitution which the Parliament has set down, and that is, it is against this template that they have created a pre-1976 and post-1976 scenario of judicial review in the latter rather than the former. The third reason
which section which page number, which section?
I'm just submitting.
No, but in relation to judicial review.
Yes.
Which section of the Constitution deals with that?
The section that deals with that is sections 2, that says, to the extent that laws, it creates a supreme law clause and says to the extent of that the laws are inconsistent with the Constitution, it is void to the extent of the inconsistency. And that coupled with section 14, which is the originating section in the Constitution, set against the template of sections 4 and 5, it creates rights. The sum total of all of that, plus the supreme law clause, contained in section, section 2. So the Constitution is the supreme law, number one. Any law that is inconsistent with the Constitution is void to the extent of the inconsistency, and the rights are spelled out in 4 and 5, and 14 provides the machinery to access those rights. So, Lord, if I may, again, what is being requested?
I thought that you were submitting that judicial review wasn't available for laws that were in existence prior to 1976.
Yes, my Lord.
And where do you find that in the Constitution?
Well, that's in section 6, my Lord. Section 6, because those laws are saved. Saved from judicial review because it is an existing law. And it precludes a review of those laws as against the template established in 4 and 5, as the case may be.
But but only insofar as they are inconsistent with sections 4 and 5.
Yes, my lord.
So the argument against you is that if a law is inconsistent with section 1, section 6 does not save it.
I take that point, my lord. But let's illustrate the point with respect to the Sedition Act. The Sedition Act falls squarely within the save laws as defined in section 6. It is a pre-1976 law, and therefore it is an existing law, and therefore it is stave. An attempt is now being made, or an argument is being offered to the court, that section 1 provides an additional limb upon which the challenge could be mounted. We are saying that that ought not to be for the following reasons. The first reason is section 1 has been construed by the Privy Council, by the board, so far, to deal only with the question of separation of powers and rule of law. They are macro-constitutional principles.
Well, how about if you had an existing law that said there weren't going to be any elections for the next 20 years?
Okay.
That's not separation of power or the rule of law. That's an electoral issue. Wouldn't that contradict section 1?
I accept that, my lord. Let me put it this way.
Yeah.
We are dealing here with speech, and we are not dealing with the election.
Can you properly confine it to separation of powers and the rule of law?
I think there might be an argument that if you suspend the issue of elections indefinitely, that goes to the rule of law, it goes to representative government, and it goes to the macro principles in our Constitution dealing with election to the House of Representatives and appointment to the Senate. It is an attack on the lawmaking functions of the state. So it goes to that is an essence of democracy in a sense, because it goes to the functioning of the legislature, which is an arm of the state which falls into the public separation of powers argument, because of the judiciary, the legislature, and the executive. And it goes to the very heart of the separation of powers argument. And this is probably why the Mauritian case was determined in that way. That is because it went, and not determined finally, respectfully, because reading of the case showed that there was some ambiguity in what they say. But it goes to separation of powers. It certainly goes to the rule of law. And it eviscerates the very heart of the specific constitutional functions or structures that are contained in the Constitution. The reason why I say that again, if I may digress a moment, is that Section 1 is not a freestanding section. Section 1 must be the right or the constitutional provision that has been infringed must be located elsewhere in the Constitution. And Section 1 is really separation of powers, rule of law in relation to some other breach, and no better example of that is found than in the case of Matadine. And if I may, without citing the specific provisions of Matadine, illustrate the point there. In Matadine, there was the issue of examinations for children, and the question of whether you could introduce an Oriental language without an appropriate period of teaching. And the challenge was mounted on the issue of discrimination. And the Mauritian Constitution contained not a generalized inequality provision, inequality before the law, or inequality of treatment by public authority, but it contained a provision dealing with the right to establish schools, I think. Now, that was not interpreted in the light of the argument as inequality of treatment. And the board was asked to link Section 1, sovereign democratic state, to that right. Now, the board accepted the fact that one of the critical underlying values that define a democracy was equality of treatment. Lord Hoffman said that pretty extensively in his judgment. And I'll find the passage in a minute. My little friend is trying to locate it from your head. It's if we look at page 2571, 2517, my dear one. Under the rubric democracy and equality, and I said before
I'm so sorry, I missed the page number, forgive me.
the electronic version is 2517, my lord.
Thank you.
The argument was mounted on the ground that Section 1 of the Mauritian Constitution, coupled with the right to establish schools, Section 3, and perhaps I can take you first to 2516 to put context into the argument under constitutional interpretation.
So 2516.
2516, my lord. The Lordships consider that this fundamental question is whether Section 3, properly construed in the light of the principle of democracy stated in Section 1, and all other material consideration expresses a general justice of principle of equality. It is perhaps worth emphasizing that the question is one of the construction of the language of the section. It has often been said in passages in previous opinions of the board, too familiar to need citation, that constitutions are not to be construed like commercial documents. This is because utterances must be construed in its proper context, etc., etc. So that is the passage I referred to a short while ago. And then we go to 2517, democracy and equality. And this is what it says. As to the formulation of the principle of equality, the court cited the judgment on the case of Rose against the police. Equality before the law requires that the person should be uniformly treated unless there is some valid reason to treat them differently. Their Lordships do not doubt that such a principle is one of the building blocks of democracy and necessarily permeates any democratic constitution. Indeed, their Lordships would go further and say that treating like cases alike and unlike cases differently is a general axiom of rational behavior. It is, for example, frequently invoked by the courts in proceedings for judicial review as a ground for holding some administrative acts to be irrational. And then they go down further at F, and they say, and Lord Hoffman says, the fact that equality of treatment is a general principle of rational behavior does not entail that it should necessarily be a justiciable principle, that it should always be the judges who have the last word on whether the principle has been observed. In this, as in other areas of constitutional law, sonorous judicial statements of uncontroversial principle often conceal the real problem, which is to mark out the boundary between the powers of the judiciary, the legislature, and the executive in deciding how the principle should be applied. A self-confident democracy may feel that it can give the last word even in respect of the most fundamental rights of the popularly elected organs of its constitution. The United Kingdom has traditionally done so, perhaps not to the universal satisfaction, but certainly without forfeiting its title to democracy, a generous power of judicial review, etc., etc. So, what this case establishes is that notwithstanding the fact that it is a Section 1, and notwithstanding the fact that Lord Hoffman opined and said that central to the issue of democracy in Section 1 is equality of treatment, that itself could not save the restricted right which was contained in the Mauritian Constitution regarding the issue of equality of treatment. And that right is a right to, I think it's conduct, to establish schools, the right to establish schools. And so therefore I make that point, Section 1 is not a freestanding right. It might very well be that the essence of Section 1 is that essence of a democracy is that it includes a right to equality of treatment. It may include a right to fair elections. It might include a right to freedom of speech. But standing on its own, it does not give life and therefore reviewability to a law which is an existing law which is saved by Section 6, because it has to be read with some other right created by the Constitution. It so happens in this case that the right which is being argued for is the right to freedom of expression, to express political views, and freedom of the press, as we have added that one. And those rights are rights which are reserved in respect of post-1976 legislation, where the courts are empowered in a post-1976 statute to review it. But the courts have said that there's a barrier, and and has not included statutes that were passed before 1976, because it has reserved unto itself the power to amend those statutes or change those statutes. As to the reason for why that is so, is set out extensively in Matthews and the other cases, Boyce and what have you, and all the death penalty cases. One of the arguments proffered is that the SAVE law was really the minimum standard on the attainment of Republican status in 76 and independence in 96. It was the minimum standard which could be subscribed to. The other view offered is perhaps it's a provision that calls for an orderly transfer of government from independence to republicanism. But the reason is not significant. What is significant is the demarcation that the constitution makers have, the line they have drawn in the sand, and the demarcation they have established. And the demarcation they have established is where it is the judiciary rights have a right to review and where they do not, in the light of the principles which I have identified for my lords. The next issue I wish to touch on, my lords, is the question of a democratic state. What are the ingredients of a democratic state? And I've already dealt with some of that. In Coriati, Lord Hoffman cited a number of principles that Lord Stein in Annie against the DPP, which he developed, and Coriati is found at 3044, and the principles which were developed, which were recited by Lord Hoffman. Mr. Das will find it for me in a short while.
3044.
In a short while. I'm sorry about that. It says this: the idea for democracy involves a number of different concepts.
Sorry, you've lost me. Which page are you on?
Yeah. Trying to.
Koirati starts on page 3044 of the main bundle, but where are you reading from?
Yeah, I'm going to. Well, mind if I find it in a little while. I'll get back to it, if you don't mind. Right? Lord Hoffman cited. You have that one? No? Yeah. He cited Annie at page 3051. 3051. Says at 3051, paragraph 11, the structure of the Mauritian Constitution. The Constitution of Mauritius 968 is important. Chapter 1 provides that Mauritius shall be a sovereign democratic state, section 1.
3051, which paragraph?
At paragraph 11, my lord.
11, thank you.
Chapter 1 provides that Mauritius shall be a sovereign democratic state, Section 1. Mauritius is a parliamentary democracy in the Westminster model. And cites Hines, the Constitution is the supreme law of Mauritius. Any law inconsistent with the Constitution is invalid. Chapter 2 spells out the various provisions for the protection of fundamental rights and freedoms of the individual. If you go down at 3052 at the very last paragraph, it says, from these provisions, after reviewing the provisions, much of which are very familiar to the Trinidad and Tobago Constitution, from these provisions, the following propositions can be deduced. First, Mauritius is a democratic state constitutionally based on the rule of law. Secondly, subject to its specific provisions, the Constitution entrenches the principle of the separation of powers between the legislature, the executive, and the judiciary. And that, respectfully, is in Section 1. And that is why he uses specifically the word entrenches, because separation of powers otherwise is a structural feature of constitutions that are not entrenched. Under the Constitution, one branch of government may not trespass upon the province of another. Third, Constitution must give each arm of government such powers as were deemed to be necessary in order to discharge the functions of a legislature, an executive, and a judiciary. While the judgment in Annie does not afford the answer to the question under consideration, it is relevant in emphasizing that 1A, Mauritius is a democratic state based on the rule of law. The principle of separation of powers is entrenched, and that one branch of government may not trespass in the province of another of any other conflict with the principle of separation of powers. So, the point being there that it goes to the structure of the Constitution. Yeah. Now, under that heading
before leaving that decision at page 3057, the board approved the decision in Valet against Ram Gulam. Do you agree with the propositions that were set out at paragraphs 39 to 41 of Valet?
I beg your pardon?
At page 3057, the board approved Valet against Ram Gulam. Do you join issue with any of the propositions set out at paragraphs 39 to 41 of Valet against Ram Gulam?
Yes, my Lord, I do. I do respectfully. For a number of reasons. Well, let's put it this way, my Lord. It depends on how we construe Valet against Ram Gulam. If Valet and Ram Gulam is construed as a separation of powers case, that is, there is an interference, or there is an allegation of an interference in the separation of powers, that is in the holding of elections and the abolition of a parliamentary government, as the case may be. And in that situation, I agree with it because it deals with the separation of powers, or alternatively with the rule of law, and therefore it goes no further than that. If it goes beyond that, and by the way, in that case, my Lord, they held that the adjournment of an election date did not attract the process of review under Section 1 of a sovereign democratic state. It did not. If it goes beyond the issue of a separation of powers or rule of law, it will fly in the face of Chandler, of Matthews, and of Suraj. And I don't think collaterally Valet and Ram Gulam can be interpreted to be more than just that.
Sorry, what were the three authorities you just mentioned? It flies in the face of
Matthews, Chandler, and Suraj.
What's the bundle reference for the first of those? All right. Don't take up time on that, but if it could be fed through to
So we'll get them a lot. I propose to take you there, financially. Now, I said before that a democratic state may have wide variations regarding their legal framework, and each state has to be looked at in terms of how its constitutional arrangements are made. Now, I take my lords to the issue of the case of Worm against the police of Grenada, which is at electronic bundle 3351. 3351. 3351. No. Yeah. Now that is a case that deals respectfully with the issue of whether it is that the offense of criminal libel, is maintainable, having regard to the fact that it's contained in Section 252 of their criminal code. And also it mentions the fact that it's set against the fact that it's a tort of libel, which is a civil remedy. It says in paragraph 43 at 3351, and this is what it says: nor can the board say that such a crime is not reasonably justifiable in a democratic society. Of course, some democratic societies get along without it, but that simply shows that its inclusion is not a hallmark of the criminal law of all such societies. In fact, criminal libel is one form or another is to be found in the law of many democratic societies, such as England, Canada, and Australia. It can accordingly be regarded as a justifiable part of the law of the Democratic Society of Grenada. Now, in that particular case, the board extensively examined the issue of whether criminal libel is an archaic charge, whether it has been there for a long time, whether it has not been used, what are the defenses open to it, and whether you can read down in criminal libel sufficient parts of the Constitution in their fundamental rights so as to give life state and bring it up to the standard, as the case may be, outside the existing law provisions. They did not decide that issue. And what it held is that there are a number of devices that can be used to infuse some life into it. And therefore, in those circumstances, the fact it was not used, the fact it was archaic, the fact that it did not have the level of precision that a modern society requires in respect of legislation, it endures because the legislation in that country catered specifically for it. And the next case is Dwarka against the Director of Public Prosecutions. And Dwarka is found at electronic bundle 2073. 2073. And Dwarka is a case that deals with scandalizing the court, or the murmuring of judges, as the case may be, as is known in Scotland.
In Scotland.
Scotland.
You can still murmur a judge in Scotland.
Sorry, I beg your pardon, Millard?
You can still murmur a judge
Yes,
in Scotland, but you can't scandalise the court in England and Wales.
This is what it says here. Now, the issue is, it's like the sedition laws, it is no longer enforced in the United Kingdom, but the movement of judges still takes place in Scotland. It's an archaic law, and it exists for all intents and purposes in Mauritius as well. And the argument was that, look, this is a very old matter, and therefore you ought not to go there. And this is what the court said at 2073. At 2073.
Paragraph
41. In conclusion, although the board would not now distinguish between small islands and larger territories merely on the ground of size, it recognizes that local conditions are relevant to the continued existence of the offense. It concludes that it would be inappropriate to depart from the decision and that if the offence is to be abolished in Mauritius, it should be abolished by statute. It accordingly answers question 1 in the affirmative.
And what was question 1?
Question 1 was whether it is that I think it's an offence. So it violates freedom of expression, or it's an offence, my lord. Question 1 is to be found at a page.
All right, don't take up time on that, so we can find it for
Thank you very much,
I think it may be
yeah.
at the start of 38, effectively.
We have situation where the charge is archaic. Different jurisdictions take a different view of it, and therefore how you look at it is very much a question of how the constitutional arrangements are made in any country. Now, the third example I have is Matadine and Ponto again, Lord Hoffman, at page 2517. 2517. 2517. And I think I'd adverted to that before, down at letter G. A self-confident democracy may feel that it can give the last word, even in respect to the most fundamental rights, to the popularly elected organs of its constitution. The United Kingdom has traditionally done so, perhaps not always to the universal satisfaction, but certainly without forfeiting its title to be a democracy. A generous power of judicial legislative action is therefore not therefore of the essence of a democracy. Different societies may reach different conclusions. So the fact that you have excluded laws which are saved laws under Section 6, which is an existing law, from the judicial review of legislation, does not mean to say that that particular country does not qualify as a democracy. And there's a further additional passage at 2518, right? And not there. 2518. Their lordship, it's a G, letter G. Their lordships think that the framers of a democratic constitution could reasonably take the view that they should entrench the protection of the individual against discrimination only on a limited number of grounds, and leave the decision as to whether legitimate justification exists for other forms of discrimination or classification to a majority decision in Parliament. There is no reason why a democratic constitution should not express a compromise which imitates neither the unlimited sovereignty of the UK Parliament nor the broad powers of judicial review of the Supreme Court of the United States. Instead of leaving it to the courts to categorize forms of discrimination on a case-by-case basis and to concede various degrees of autonomy to Parliament, only as a matter of comity to the legislative branch of government, the Constitution itself may identify those forms of discrimination which need to be protected by judicial review against being overridden by majority decisions. So it deals with the allocation of powers under the Constitution and how it is that the framers of the Constitution allocated the powers of judicial review, as the case may be. Now, my lords, there's no need to refer to it, but my lords would, of course, be familiar with Chandler. And in Chandler, if you look at page 2053, at paragraph 98, and this is what is said in Chandler: laws which predate the creation of the 1976 Constitution, but for the Savings Clause, would be exposed to constitutional challenge for breach of the fundamental rights and protections in sections 4 and 5 of the Constitution, will continue to exist only so long as Parliament chooses to retain them. it is striking that there remains on the statute book a provision which, as the government accepts, is a cruel and unusual punishment because it mandates the death penalty without regard to the degree of culpability. Nonetheless, such a provision is not unconstitutional. The 1976 Constitution has allocated to Parliament as a democratic organ of government the task of reforming and updating the law, including such laws. And the same principle applies here, because the death penalty in Trinidad and Tobago is prescribed by a saved law, but for the fact that it is saved under Section 6. And what can be more heinous than that? The fact that it is saved by Section 6 does not allow the judiciary access to the usual principles that accompany judicial review to have it dealt with. And the other case I wish to refer to is the case of Pinder.
Well, sorry, just on Chandler, how does paragraph 98 help us? We're addressing an argument that it's not sections 4 and 5 that make this law unconstitutional, but section 1. And you've accepted that section 1 has an independent life apart from sections 4 and 5.
I've accepted the fact, my lord, that section 1 has an independent life insofar as separation of powers and rule of law is concerned. I've also accepted the fact that sections 6 saves laws that will otherwise be declared cruel and unusual, or otherwise violate sections 4 and 5 of the Constitution. And the argument is, both in Chandler and Shiraz, which I will get to in a minute, right, where a challenge was launched in both of them in respect of the death penalty being a peculiarly deals with the question of punishment, and therefore fell within the separation of powers. And what was deployed in that case is the fact that, notwithstanding the fact that it violated 4 and 5, Section 1 was not sufficient to allow it to get past the bar that will require judicial intervention, and that it is very much part of a democratic state, which is Section 1, which is specifically mentioned in 98, which is Section 1. So a country can be democratic, but at the same time, the democracy is not eviscerated or removed, and can quite compatibly lie side by side with the extremely heinous penalty of mandatory death penalty for murder, as the case may be.
What did the board say about coirati in Chandler? Can you help us with that?
The board distinguished coirati in very much the same terms I did, and that is as follows. If I may just summarize it. The first thing is that the separation of powers is not a supra...
I'm sorry, whereabouts in Chandler do they distinguish it?
They deal with coirati, my lord, at paragraph 91.
Right.
I think they start dealing with this at paragraph 85 on page 2050.
Yeah. Paragraph 85, that's right, my lord. Yeah. Let's go straight to 87, my lord. The board agreed with the Supreme Court of Mauritius that the 1994 Act was in breach of Section 1 of the Mauritian Constitution and was invalid, as it had not complied with the constitutional procedures introduced by the 1991 Act. Lord Stein, delivering a judgment to the board, referred to the board's decision as Annie, and stated at paragraph 11 that the judgment of Annie case did not afford the answer to the question under consideration. It is relevant in emphasizing A, that Mauritius is a democratic state based on the rule of law. B, the separation of powers is entrenched, and C, that one branch of the government may not trespass on the province of any other in conflict with the principle of separation of powers. And then he goes on to say, the idea for democracy involves a number of different concepts, and then that is defined there. And then Lord Steyn reasoned as follows: decisions of bail are intrinsically within the domain of the judiciary. That is, for example, in this case, the pronouncement of a penalty for murder is the case in which a sentencing issue. Section 1 was not a preamble, but a legally enforceable position. I accept that absolutely. Section 1 and Section 57(2), which provided for quinquennial parliaments, had been deeply entrenched by the 1991 Act. And for, as a result, both the purported constitutional amendment by the 1994 Act and Dangerous Drug Act, which prescribed the offences for which bail is removed, was void because the Constitution had not amended according to the procedures introduced by the 1991 Act. And then they go on to quote Lord Roger. And then at 91, the focus of the board judgments in Kuriati was on the implicit recognition of the principle of separation of powers in the legal guarantee that Mauritius is a democratic state. In the board's view, the distinction between Kuriati, in which bail was recognized as being inherently a matter within the province of the judiciary, and the present appeal, is that the fixing of the mandatory penalty for everyone who commits a particular offense is inherently a legislative matter. And that's because it is saved by 6. Lord Mann's reference to the principal rule of law leads to a consideration of Mr. Fitzgerald's submission that there is a justiciable principal rule of law on which the board turns. And then they go on to discuss, the board goes on to discuss, the appellant argued the rule of law is a justiciable unwritten constitutional principle in the 1976 Constitution. And all of that is accepted, my lords. All of that is accepted. But what is different between Kuriati and between Chandler is that in Chandler, the penalty was saved by Section 6. And in Kuriati, what they had not done is the Parliament, in amending the Constitution, there was no save provision firstly, and had not reached the threshold standard by which Section 1 was entrenched.
Can you help us? Did the board deal with Mollinson in Chandler number 2?
Yeah, Mollinson is a case that deals with the question of the reviewability of sentence for someone who has been sentenced at the state's pleasure or the Governor General's pleasure.
And yes. Is there any reference to Mollinson in this authority?
Yes. That's what? 7 what? Paragraph 76 of Chandler.
Oh, yes.
76, is it? Yeah. Yes, there's Mollison cited there as well. So despite the fact that Mollison dealt also with the question of the circumstances under which he could be incarcerated, that's a separation of powers case, as it is in respect of Kuriati. It is also the same in respect of Chandler, but the distinguishing feature of Chandler is that the section was saved by Section 6.
Well, is that quite right? I mean, as I read paragraph 91,
paragraph, my Lord,
referred to, paragraph 91 in Chandler.
91.
I mean, I read that as the board saying there isn't a breach of Section 1, because fixing a mandatory penalty for everyone is inherently a legislative, not a judicial function. So there's no breach of the separation of powers principle.
Well, that might be correct, but I think the case was basically also substantially decided on the fact it's a saved law. And
no, the board had to address 2 distinct issues.
Distinct principles, yeah.
And what we're interested in is them addressing the argument based on Section 1, because that's the argument you have to face.
That is a separation of powers argument, my
yes,
Lord.
and
that
the
is
board
what
did have to address an argument.
And that's what I'm focusing on, my Lord.
Right.
And that is the issue of the distinguishing feature is the question of whether it is that if a law is saved, but yet the law still violates the separation of powers, whether Section 1 provides an independent ground for judicial review. And Chandler answers that in the negative.
No, I don't think it does.
No, it doesn't.
Because the board rejected the argument that the mandatory death penalty breached Section 1.
That is because it was a saved law, my Lord.
No, No, it was because it was a legislative function, not a judicial function, as I read paragraph 91, which you've just referred us to.
Well, Suraj provides some further learning on that, and perhaps I can go there.
Yeah.
But let me deal with...
Well, perhaps we had better just make sure that we have understood Chandler number 2 correctly. Like my lord, I thought that the whole part of the judgment, really from paragraphs 76 onwards, Wallinson and so on, was to explain what principle could be derived from Section 1 of the Constitution, and then which, in so far as was relevant to that case, was an issue relating to separation of powers, and then to say that actually Chandler itself was not concerned with any infringement of that principle. And as my lord says, that's the basis for the need to distinguish Koirati, which was based on Section 1.
Well, can I take you the head note, my lord, if I may, at 2002? It says, dismissing the appeal, that Section 4 of the Offences Against the Person Act was an existing law for the purposes of Section 1 of the Constitution, and therefore was preserved from being invalidated by anything in Sections 5 of the Constitution, and was made to conform to the Constitution by disapplying Section 5 thereof. That the power in section of the Constitution of the Republic of Trinidad and Tobago to modify a law to make it conform to the Constitution is only available, was available only where the law in question was not in conformity with the Constitution. So that not given the powers, court powers to modify a law whose invalidity was preserved by the Constitution, that such an interpretation was consistent with the wording of the Constitution, properly given priority to the Constitution as the supreme law of Trinidad and Tobago over the 1976 Act.
Yes, and then if you read on, that further, the doctrine of separation of powers is not an overriding principle. So that's where the head note is dealing with the sections of the judgment that we've just been looking at,
yes,
which deals with a completely distinct argument, not based on Section 6
okay,
of the existing law.
Well, and that is why we say that Section 6 attenuates the separation of powers principle. In other words, if it is one, that it is a save law, or alternatively, if the legislature has the power to determine what is an offense and to determine what is the penalty in respect of that offense, notwithstanding the fact that it violates 6, it cannot be put as against 1 and struck down on the basis of separation of powers, on the basis of a separation of powers, because the separation of powers doctrine is attenuated by Section 6 of the Constitution.
Would it help us to look at paragraphs 93 to 95, and in particular the end of paragraph 94, where the board deals with the distinct argument based on the rule of law and says that those provisions,
yes,
are disapplied by Section 6. It would undermine the coherence of the Constitution if that which Section 6 is disapplied were nevertheless to be applied through the invocation of the principle of the rule of law.
Yes, my lord, that helps us.
Is that of any assistance?
Yes, my lord, that helps us, because out of the rule of law flows the separation of powers principle. The board is not persuaded in 794, the board is not persuaded it is possible to erect the rule of law into a justiciable, unwritten principle, which can be separated and untethered from the specific provisions of sections of the 1976 Constitution, namely Section 6. The board has already expressed its opinion on the separation of powers, 75 to 91. Just as the principle of separation of powers arises by implication of the provisions of the 1976 Constitution, these provisions are also at the source of the principle of the rule of law. The 1976 Constitution eschews and so upholds the eschewal of arbitrariness and the principle of equality before the law in sections 4A and 4B. And it goes on to cite that See, for example, Francis. The principle of the rule of law must be considered in the context of the 1976 Constitution as a whole, and the Constitution interpreted as a coherent whole. The aspects of the rule of law upon which Mr. Fitzgerald relies are articulated in sections 4 and 5 of the Constitution. Those provisions are in the boards explained disapplied by section 6 of the Constitution. It would undermine the coherence of the Constitution if that which section 6 has disapplied were nevertheless to be applied through the invocation of the principle of rule of law, that being section 1 as the case may be. I don't know if that helps, my lord.
Well, I mean, speaking for myself, it seems to me that the analytical framework within which Chandler was decided is tolerably clear, that section 1 is an independent provision that isn't directly affected by section 6, the saving for existing laws. So you can have something which is an existing law, but which could, in theory, infringe some substantive content to be given to section 1. But as my lord points out in paragraph 94, the board has looked at how one determines the substantive content of section 1, in part by comparing it with the subject matter, which is covered by sections 4 and 5, yes. And indeed section 6, and says, well, you have to construe the whole Constitution coherently, and that rather suggests that there isn't an extensive overlap, or is not intended to be an extensive overlap between section 1 and the regime in sections 4 to 6. And I mean, this seems to me to be broadly supportive of some of the submissions you've been making, that the substantive content of section 1 has to be taken to be narrower than that.
You can't untether...
Am I wrong? Tell me if I'm wrong.
No, that's correct, Mel. You can't untether section 1 from the rest of the Constitution, particularly section 6.
Right, but it still does have some independent substantive content over and above what one gets from sections 4 to 5, doesn't it?
In the restricted circumstances of where you have a law which is not an existing law and which violates the separation of powers argument or the rule of law argument. Now, my lord, may I take this right back?
Quite irrespective of section 6. My Lord Sale's question was, does it have content over and above sections 4 and 5? And if so, what are the parameters of that content?
The content...
Just ignore the existing law, but just look at it just as two simple routes to verdict, okay?
The content... Sorry, I beg your pardon.
Okay.
The content, my lord, is first of all, it speaks to the separation of powers. And more specifically, separation of powers, and generally the rule of law principle. It does not have as a part of its content any one of the rights identified in sections 4 and 5 of the Constitution. More particular, right to freedom of speech, expression, or to express political views. Unless you can validly mount an argument that it is, unless you can validly mount an argument that it breaches the separation of powers doctrine or the rule of law doctrine. Section 1 doesn't give you an independent right of review in respect of that particular issue. For example, Mollison is an example of that. Mollison is a sentencing case.
If I could, I'm sorry for interrupting, but at an earlier stage, I suggested a law, a fictitious law, no doubt, that there wouldn't be elections for 20 years. And you said that fell within section 1 because it was the separation of powers and the rule of law, both those things.
Arguably, my lord.
Yeah.
For this reason, my lord, if I may.
Right.
For this reason is that section 1, like in Martindale, has to be tethered to some other provision of the Constitution that will give it life. For example, in Martindale, it was the question of discrimination. When you put section 1 in the Mauritian Constitution, sovereign democratic state, together with the discrimination provision in the Mauritian Constitution, the end result is section 1, although it is a core part of the democratic principle, could not stand by itself to strike down the discrimination law. because the discrimination law in Mauritius did not cover examinations for children and therefore inequality of treatment. So in the case that you mentioned from Sri Lanka, I said possibly there could be an argument there because there were other provisions in the Constitution, because the Section 14 does not relate only to, Section 2 does not relate only to fundamental rights. In the Mauritian Constitution, like the Trinidad Constitution, there are specific provisions relating to the holding of elections and the constitution of a parliament and the life of a parliament. So, for example, in Section 68, it says, subject to subsection 3, Parliament, unless sooner dissolved, shall continue for 5 years from the date of its first sitting after any dissolution and shall then stand dissolved. So if, for example, you extend the life of a parliament, other than in a state of emergency, and I should add that, and you say, look, you have violated a provision of the Constitution and therefore violated the separation of powers argument in that you are not allowing us the right to an election on a timely basis, tethered on to the provision of the Constitution that is contained in Section 68, you would have a separation of powers argument. You might, and in that particular case, the Mauritian case might be invoked to set it aside. In Mauritian case, what they did is extended the time, but it violated no constitutional principle. Yeah. Yeah. Might I take you to Suraj, my lord? Unless I can help you further on that point, I don't know.
Yes, please take us to Suraj.
Section 3170.
Sorry? What was the page number?
3170.
Thank you very much indeed.
Yeah. Now, as my Lord Sales knows, Suraj is a case dealing with the question of regulations which was saved. I'm sorry, an act which was saved, the Public Health Act which was saved. And the ordinance that was made, the regulations were made pursuant to the act.
Is that reference right?
3170.
Thank you.
Yeah.
And which paragraph do you want us to look at?
I'm in paragraph 119, starting in 119. The appellants argued that the ordinance itself is unconstitutional and inconsistent with the notions of a sovereign democracy and constitutional supremacy, insofar as it vested the minister the sole unsupervised power to make infringing regulations without reference to Parliament, as the content happened in this case. The assumption that the minister still has powers to pass laws with the same width and scope after independence as he enjoyed before independence undercuts the supremacy of the Constitution expressly guaranteed by 2, by which the previous colonial constitutional order founded on parliamentary supremacy was overridden. The short answer to this is that the rules are not infringing regulations, but had they been, they would have been unconstitutional by reason of sections 4 and 5 of the Constitution. In any event, it is made clear by the board judgment in Chandler. General notions of sovereign democracy and constitutional supremacy cannot be separated or untethered from the specific provisions of the Constitution, see particular 75 to 95. As made clear in addressing issue 2, the Constitution does not mean that the rules could only have been made under section 7 and 12 of the Constitution concerning public emergencies, and for the minister to have partly overlapping powers under ordinance is not unconstitutional. It follows that the use of such powers would be contrary to the notions of a sovereign democracy, and such powers would be contrary to the sovereign democracy and constitutional principles reflected in the Constitution. It can be conferred, etc., etc., etc. Constitutional supremacy is respected by the checks available to ensure the rules are consistent with the provisions of the Constitution. So there was a challenge, my lord, to an ordinance made, which was a safe law, and the ordinance was now challenged on the basis of section 1, sovereign democratic state. It was a safe law, and the court said, no, it is not a safe, it is a safe law, and therefore it's not challengeable independently of Section 1 because it does not deal with the issue of it does not deal with the question of separation of powers and rule of law. Could you bear with me a minute? I'm looking for an extract from Chandler that deals with Section 1. Yeah. Yes, my Lord. If I look at paragraph 84 of Chandler, I don't know if I read that at page 2050. 2050.
Chandler.
Yeah.
Paragraph.
84.
Thank you.
The appellant also seeks to raise an argument that Section 1 of the 1976 Constitution, which declares Trinidad and Tobago to be a sovereign democratic state, contains by implication a specific requirement that punishment should not be arbitrary and must fit the crime. In this case, violating freedom of speech. In this case, violating freedom of expression. This is an ambitious submission. The board does not have the assistance of the courts of Trinidad and Tobago on the occasion whether the general declaration can provide any basis for a constitutional challenge to the mandatory death penalty. The board will be very concerned to adopt what would be a radical development of the interpretation of the 1976 Constitution without the assistance of the views of those courts. In any event, the board does not consider that the argument based on Section 1 of the Constitution can add anything to the separation of powers argument which the appellant has advanced and which the board has rejected. They were contending in that case that the separation of powers argument, which is inherent in Section 1, violated the power of the courts to impose a penalty of death, a mandatory penalty of death, in circumstances where that penalty of death was saved by Section 6. Right? So the argument really turns on the structure of the Constitution as it does in Matadine. You know, how do you look at Sections 1 to 14, which are particularly engaged here, and find out of it a coherent principle of law? And it has to be that there's no one section takes precedence over another section, and that's the first rule of interpretation. The second rule is that 1 to 14 has to be read as a coherent whole, and therefore you can't say that there are exceptions created here and there, they must be read together. The third principle is that if you have a section that saves pre-existing law, 1976 laws, pre-1976 laws, and judicial review is not permitted of those laws as against 4 and 5, you can't therefore say, look, you are saved in respect of 4 and 5, but I can now go to Section 1, because Section 1 itself is only confined to two things: separation of powers, rule of law, and separation of powers as a subset of that.
You've said that a number of times, but isn't it fundamental to democracy that the people choose their rulers? Which is not really a question of separation of powers or the rule of law, is it? I mean, both those precepts are said in Chandler to be implicit, but a democratic society is express.
Yes, my Lord.
So you're saying that Section 1 contains no express principle, only implied principles.
Section 1, the notion of a democratic...
The right of the people to choose their representatives to govern Trinidad and Tobago, do you say that forms no part of Section 1?
That could, my Lord, on the basis of the Mauritian case, because it deals with separation of powers.
But
it does
I
not
don't know why you interpret democracy as simply being a form of separation of powers?
Because the authorities point in that direction.
I see. Which authority do you rely on?
First of all, the authority of Matadine, where they try to invoke Section 1, which is a sovereign democratic state, with a very limited provision relating to discrimination. And Lord Hoffman in Matadine...
That's not they're concerned with how fundamentally the country is governed, is it?
But the question of freedom of speech, well, no. Lord Hoffman said in Matadine that the issue of discrimination and equality of treatment forms a central tenet of the democracy. He said so very specifically, and yet notwithstanding that, there was not an independent right under Section 1 to challenge the law, which was very limited in respect of discrimination.
Right. So really Matadine is probably the main authority you rely on.
The main authority.
Thank you.
I wonder whether it might be right to go back a bit further than that. So, I mean, Mollinson, for example, refers back to what was a seminal decision of the board, judgment delivered by Lord Diplock in Hines.
Yes, my lord.
And there, the structure of the argument was in the various constitutions which adopted the Westminster model, there were fundamental features of what a democracy according to that model comprised, including a very strict separation of powers doctrine. But clearly, the Westminster model, for instance, at the time of the constitution in Hines, which was Jamaica, I think, and the various other constitutions, including certainly the 1962 constitution, and indeed the 1976 constitution in Trinidad, did the Westminster system accommodated a law of sedition and seditious libel. We've seen from the Law Commission report that was only abolished later on. So I wonder whether it might be said, well, although one can spell out some features of democracy which were either implicit or, as my lord says, express in relation to a Westminster model, since if you had a Westminster model and elections abolished for 20 years, one might readily say that that was inconsistent with democracy as understood in that model. But nonetheless, aspects of debate about freedom of speech are not inherently contrary to democracy as understood according to that model.
That's correct, my lord. It's covered by 4 and 5. And it's also confined, the judicial review is confined to post-1976 laws, and it is left to the legislature, according to Lord Hoffman and Matadine, to deal with the granular aspects of it. Let's put it this way, my lord, if I may. Section 1 does not deal with fundamental rights, because the separation of powers and the rule of law is really an interpretation principle, and this is what Lord Diplock said in Hines. He says that it's an interpretation principle, that's number one. And Lord Hoffman has repeatedly said, and Lord Bingham, it's not a supra-constitutional principle that overtakes everything. And thirdly, if you have an issue that you have here in respect of freedom of speech, I don't see how respectfully it can be embraced within the separation of powers doctrine, although it's an integral part of democracy. Because otherwise what you have is an untethered principle of sovereign democratic state being extended at large in circumstances where specific and granular rights are spelled out in 4 and 5. And therefore, where does it begin and where does it end? And therefore, without any kind of legislative guidance, what you may possibly have is a duplication where it is that rights, the Parliament has specifically said, these rights are in respect of laws that are passed after 1976, and those are the rights of judicial review given to the courts. Now, if you take out of that the notion that you can now use the principle of a sovereign democratic state and read into it matters other than the separation of powers and the rule of law, and you take it to the granular of freedom of speech In the case of Mauritius, inequality of treatment, freedom of the press, the right to express political parties. Not only do you have a duplication, but you have a situation in your hands where now the courts are allowing itself to review saved law or existing law which is saved in circumstances where that is not permissible under Section 6, and opening an entirely new front without any legislative guidance which the legislature has reserved unto itself on the basis of Chandler and on the basis of all of those cases that existed before.
My understanding is that your proposition is that freedom of speech isn't inherently a feature of democracy within Section 1. Would that be a question of degree? Insofar as if you had a law that banned all debate for 3 months before an election, would that be such a fundamental interference with the democratic principle that it would not only be a breach of Section 4, but also would be a breach of Section 1? The proposition that freedom of speech isn't inherently a feature of democracy is, I can see arguments at the edges of it, insofar as obviously you restrict freedom, well, some countries restrict freedom of speech on the day of the election, so that doesn't interfere with the election. Some countries make sure that political parties have equal amount of airtime. So those are limitations. But the most fundamental breach of the freedom of expression for a long period of time, wouldn't that be a breach of the democratic principle?
The issue, my lord, is what are the constitutional arrangements which have been made. And I take you to that point because I think that in every single case, what constitutes a democracy and what rights are justiciable is a function of the structural arrangements that have been put in place by the Parliament in respect of the Constitution. In Trinidad and Tobago, what we have is freedom of speech being protected by 4 and 5 in a post-1976 scenario. It is impossible to speculate, but it is respectfully not appropriate to speculate as to whether a law existed to that effect before 1976. What we do know is in the case of the death penalty, which is as heinous as you can get in a pre-1976 scenario, that argument is saved, and that argument, although it goes to the heart of the sentencing system, it is not violative of separation of laws because of the not a super-constitutional principle, and it is not envisaged that a law which is saved can now be trumped by Section 1 of the Constitution. Notions of democracy vary from country to country. Every single country has its own notions. For example, in the case of Pinder, which is mentioned in our submissions, Pinder is a case where flogging was abolished in the Bahamas in 1984 and reintroduced in 1991. Flogging is a heinous, cruel, and unusual treatment and punishment. But the Privy Council, the board said, yes, you can do that because your constitutional arrangements, it permits you to do it.
But surely, if I may say so, my Lord Stevens is right, isn't he, that at some level one can debate at precisely what point freedom of speech is fundamental to democracy, isn't it?
Yes, we accept that, my Lord.
Right. So if it is, then at some level, doesn't Section 1 provide a degree of protection independent from Sections 4 to 5 for freedom of speech, if it's fundamental to democracy, which you've just
respectfully
accepted?
no, in respect of a pre-1976 law.
But I didn't, when you gave your answer, I didn't understand why you were focusing on pre-1976 laws.
Because
suppose a law, such as my Lord proposed to you, introduced tomorrow. So forget about past laws. Indeed, it seems unlikely that there is any past law to that effect, but suppose a law was passed tomorrow saying that 3 months before an election there may be no political speech. Would that not be inconsistent with the fact that Trinidad and Tobago is to be a sovereign democratic state?
Respectfully, Millard, it might be, but your redress would not lie within Section 1 the way it is interpreted. It will certainly violate 4 and 5, but the sovereign democratic state, a sovereign democratic state must contain a substantive right in the body of the Constitution, because the idea of democracy under Section 1, in accordance with Matadine, by itself cannot stand to give you redress in respect of a violation of what is like freedom of speech, a freedom of speech law passed in 2023. It must be tethered to some law or some right in the Constitution post-1976. And Matadine is about that. There was no existing law in Matadine. What happened was there is a discrimination provision. And the court held, looking at 1 and looking at 3, it says, look, inequality of treatment, because there's an argument against discrimination. That didn't carry you so far, and certainly Section 1 itself doesn't take you there. And even when you conflate both of them together, it does not give you the right to redress. And that is very, very clear from what is contained in Matadine.
I think you took us to the concluding paragraph of Chandler, where the state accepted that the death penalty was a cruel and unusual punishment, but the board said it was a matter for the legislator to form a view about it. And as just as a matter of information, what's the state's view about the
Sedition Act? Thank you very much.
The Sedition Act, yes.
Well, the Sedition Act, Volume 1. Yes, my Lord, I'm very happy I got a chance. 5. Yeah, could I just take you to those provisions, my Lord? I know. Section Volume 5. Yes. The Sedition Act is found at what? 3407. 3409. Where is it? What is it? 3409. 3409.
If this wasn't an existing law, would it fall foul of Section 4 of the Constitution?
Accepted, my Lord.
Yeah.
Same thing in Chandler as well.
Yeah.
Now let's look at this. We don't even accept the fact that this violates freedom of speech, because we deal with a number of principles. First of all, in approaching this...
Sorry, I thought you just accepted that it would fall foul of Section 4, but that's wrong, no?
Well, let's put it this way. There are some parts of it that are vague, and I will respectfully suggest to my Lord that there is a body of law that tells you how you might interpret it. Now, in Chandler, the state accepted that the death penalty, as you mentioned, is cruel and unusual treatment and punishment. Now, let's deal with this. The first thing that has to be done is this legislation has to be looked at in its historical context. And many countries of the world still have provisions in respect of sedition. And Canada and India, it was abolished in the UK in 2009 and several other Caribbean countries. That's the second point. And the historical context that is important in interpreting this legislation. The second issue is the issue of I take you to, if I may, Section 10 of the legislation. It says, nothing in this act prevents a prosecution under the common law or under any other act, but a person shall not be punished twice for the same offense. So the common law sits side by side with this provision. The third issue is that No one has been charged. So what the court is asked to do is look at the entire section, look at the entire act, and strike down the entire act. The fourth principle is this, that if we look at 3.1 and 3.2, we would see, of course, a defense that is contained in section 2, section 3.2, but an act, speech, statement, or publication is not seditious by reason only that it intends to show that the government has been misled or mistaken, or point out errors or defects in the government or the constitution by law established. So if you, for example, if a person does any of those things there, he will say, look here, I have a lawful excuse to do so, very much like Ziegler. There's a lawful excuse to do so. Let's look at D, to engender or promote feelings of ill will or hostility, and D2, feelings of ill will or hostility. That's covered by the defense of lawful means in sections 3.2. Sections 3.2. The third thing is that there is a provision in 3.3 dealing with the issue of intention, on whether it is subjective or whether it is objective is a matter very much up in the sky, because the little friend says it's an objective test, the test of a reasonable man. But the fact is, it's not a strict liability offense. The third issue is the question, or the other issue is, how does a court approach something like this? Using the case of Worm, which I reverted to before, the fact that it hasn't been used or already used is not an issue on which it can be struck down, because there is no principle of judicial review under the common law that can strike down the legislation. That's the other point. The third point is that in any statute, the common law has devised a number of measures when given directions to the jury or when informing itself about an offense. And what it does, it works on the basis of presumption of innocence, proof beyond a reasonable doubt in a criminal matter, the question of mens rea, the question of proportionality, as in Ziegler, is it? Ziegler, the question of proportionality and all of that, right? And then those are some of some that come to mind immediately. The fourth thing is in Worm. Worm is a Grenadian case, and it invokes the principle of legality. That is the principle contained in the case of Sims, right? And when you're reading this section, like in Worm, you have to look at the principle of legality. And therefore, the learned friend says that this section does not expressly make any provision in respect of violence, incitement to violence, right? And, well, the issue is that we are asked now to declare this law violating Section 1, ultra vires, null and void. Now, that is an ambitious proposition without a set of facts, especially having regard to Ziegler, where you have to have a fact pattern established in order to determine the issue of proportionality. We go to the principle of legality. And what you do, it is said very clearly in Worm, that what you do is you read into the statute. Could you find it, please? You read in, Worm is a case from Grenada. You read into the statute, what? Paragraph 27 at page 27 Yes, at paragraph 27, at the very end of 3344. It says, this is a case of criminal libel. Court was faced with a very difficult situation here because criminal libel had been long abolished in many countries, and the court made the point as well that because criminal libel exists in a country, and I've given the citation to the court before.
So I've read that, the last sentence of paragraph, or the last two sentences of paragraph 27. What are the constitutional provisions that lead to a different meaning being given to the Sedition Act?
Well,
and what are the different meanings that are given?
Well, if there is ambiguity in the section.
Well, for instance, does it require incitement to violence?
I would say yes, my lord.
Right.
Although I would not agree with the case out of the Gold Coast, out of what is now Wallace, which is now Ghana. I would say because of the fact that the common law exists in Trinidad and Tobago as a separate set of facts upon which you can charge someone, I will say that because of the fact that the common law exists and there's a statutory offense existing, when you look at Stevens and you use the common law to aid the interpretation of the legislation, what you might possibly do in the light of the Constitution is you say, look, there's a freedom to express political views, there's a freedom of speech, and therefore I need to read into that statute. And without changing it in any major kind of way, there's also a requirement of incitement to violence. Now, I know that in 1940, the Wallace case out of Ghana, the Privy Council said, no, that is not the position then. But then we are dealing here with a situation where there's a living tree doctrine, and therefore legislation must be construed against the light of the constitutional and legal development since then, and the more enlightened approach to the interpretation of statutes as well as the living instrument. So respectfully, what has to be done, therefore, is that the act has to be read as a whole, and the incitement to violence. And what you do is you read it within the context of lawful authority, and you read it within the context of proportionality, because the section does say that if I may look at the Sedition Act again.
3411.
What, sorry?
3411.
I beg your pardon, Lord. 3411. It does say in section 3.2, misled or mistaken is measured to point to errors or defects of the government or constitution as by law established. And then in the fourth line, it's talking about lawful means and lawful means, as the case may be. So therefore, if it is that you try to persuade someone about something, and you do so legitimately and properly, and no matter how vociferously and obnoxiously you do so, there must be some additional ingredient there, and the words lawful means, in my view, will import a requirement to read into it. You read into it an incitement to violence or disorder, as Stevens says. The passage is there, and we can get Stevens for you in a little while, Millard. So
Hussain, I think it's time to bring your submissions to a close now.
Okay, well, Millard, I thank you very much. I'm sorry that I took so much time, but I just sort of was responding to that.
Of course, you were responding to questions, of course.
Sorry?
You were responding to questions,
yes,
of course.
Millard,
yes. But it's time to...
Yes, Millard, well, thank you very much.
I'm not asking you to sit down immediately, but you need to conclude your submission.
Yes. Well, we are here, Millard. I mean, the only other point I wish to make is a passage from Lord Bingham, where he said very clearly that it is for the legislature of a country to make the laws, and I can find it after after I sit down, my lord, but it's one of the death penalty cases. If you bear with me one single moment, because
Well,
can I do it for
you can give us a reference. You can give us the reference later.
Yeah, I can give you the reference at some other point, my lord, if I may.
Of course.
Or just before we rise, I can find it, I can point it
Thank
out
you,
to
Mr. Hussain.
Thank you very much, my lord.
Very grateful.
Grateful to you.
Mr. Knox.
My Lord, my first point is this. In response to the point that it's difficult to decide this matter in the abstract, the proceedings were properly brought. There's no doubt about that. I've shown you the history before. And in my submission, there's no difficulty in deciding the constitutionality of this provision without specific facts. You know, a speech was given, or a talk was given, the premises were searched, he began proceedings to prevent a prosecution, and then he died thereafter. I mention in particular, Central Broadcasting has a very intimate interest in this matter because it's a broadcaster. Another related point was this. My learned friend suggested that you could read in some sort of intention, relevant intention, into the Sedition Act. In my submission, I don't think that submission has been made before in this case, but in my submission there are great difficulties with that. First of all, the Wallace-Johnson case, which was on a very similar sedition law, which likewise did not have an intention to incite violence and so forth. The board went out of its way to say, in page 3323, but in particular at the end of 3323, that you couldn't read in a specific, the intention which Stephen had said should be read in, or that the Canadian court was prepared, Supreme Court was prepared to read in on the different wording of the Canadian Criminal Code.
But in relation to this Act, why not, since it seems so obviously inspired by Stephen's statement of the law in 1888, and we know from the Law Commission that that is taken to include incitement to violence?
Well, my Lord, the words simply aren't there. Nothing in Hansard suggests that they were supposed to be there.
They weren't there in Stephen's formulation of the offence, which it seems to have been the inspiration for this provision, but it was understood since the late 19th century that nonetheless there was a requirement of incitement to violence.
That was precisely the point that Wallace-Johnson rejected. Right. He said these words are clear, and it's a very similar statute, the words are clear. That's one point. The second point is this, de Freitas, 20891. There is a real problem in my submission with overbroad legislation which restricts freedom of speech, because what it does is it creates a chilling effect, and it is in my submission wrong, and this is a point made in de Freitas. If you have an overbroad restriction, the problem is it puts people off, and then the state comes along at the end and says, oh, well, I'll tell you what, why don't we just read this all down, and we get round the problem. And my Lord, that is it's a passage in de Freitas at 2089, which recites from a decision of the, I think, Supreme Court.
Sorry, page
2089, subpara 1, or Roman 1. Right. And says that is objection. That's an objectionable way of proceeding. And it's a little bit like restrictive covenants in employment cases. One thing you can't do is say you can't work anywhere else in the world for the rest of your life, and then hope. Then eventually you go along to court and say, well, I'll tell you what, I can make it a little bit more reasonable now. You can't do that. And my Lord, that in my submission is the objection to what you might call reading in, unless it's easy to read in, unless it is natural to read it in. If it's not natural to read it in, you're actually changing the structure and content of the Act. So those are my two answers on that. My Lord, on the democratic state point, a fairly obvious point, all that Section 6 does in its terms, it may just be worth looking at, is to prevent a finding of invalidity for non-compliance with Section 4 and 5. And can I just ask you to look at page 3379? Of 3379, nothing in sections 4 and 5 shall invalidate an existing law, and of course sections 4 and 5 are the rights provisions. In my submission, it is absolutely plain that the blanket ban, or the ban in section 6, does not apply on its own wording to any other type of inconsistency. That's clear from the wording. Secondly, my lords, it's trite that one construes savings clauses narrowly. And thirdly, my lord, I mentioned in opening the various cases which have applied the narrow construction to Section 6 and held you can challenge for incompatibility with the Constitution if there's another provision in the Constitution that's been infringed.
Sorry, what held that?
Mollison.
Mollison, right.
That's our supplemental bundle, page 45. Sukran by Madam Justice Gobin at 2295. That was the privilege case. Then Achilles Charles, which is a Court of Appeal decision, at 1697 to 1698, paras 67 to 69, and Balwant, which is in our supplementary authorities bundle. It was a Privy Council decision.
Yes, I had a quick look at that over lunchtime. I wondered if you'd given us the wrong reference. I couldn't immediately see.
Para 13, I think.
13. Which is the page?
My Lord, perhaps I can come back in a moment.
Yes, certainly.
My Lord, the next point is about Koirati. I submit it is clear, the fundamental point is that in Koirati approved valid. And that is clear from that one can properly infer that Section 1 is intended to give self-standing, it creates a self-standing obligation, if you like, on the part of the state, which, if breached, can give rise to a claim by a citizen. Now, my learned friend says that Section 1 applies only at a macro level, such as arguments based on separation of powers and so on. I just say the following. First, no authority says that Section 1 is limited only to separation of powers, attacks, or rule of law arguments. Secondly, nothing in Chandler says this. And in particular, can I ask you to look at paragraph 81 at 2049? One has to understand what the reasoning was. And my lords, I apprehend your lordships are familiar with this point, but I do just want to emphasise it. 2049, paragraph 81. The fundamental problem Mr. Fitzgerald's argument ran into in relation to separation of powers, he's complaining about the mandatory nature of the death penalty. The problem is pointed out in paragraph 81, my lords. Perhaps I could just ask you to look at the first few sentences of paragraph 81, the difficulty which the appellant's argument faces. And so one has to take as the starting point that the separation of powers argument was always going to fail because it was for Parliament to fix the penalty. And if that's right, then there couldn't be an attack on the mandatory death penalty. That's the underlying reasoning. And then goes to paragraph 84, which is the beginning of the Section 1 argument. And that argument is then considered, or rather Koirati in Section 1 is considered until you get to paragraph 93. But in paragraph 91, we'll see what they have to say here. The focus of the board's judgments in Koirati was on the implicit recognition of the principle of the separation of powers in the legal guarantee that Mauritius is a democratic state. In the board's view, the distinction between Koirati, in which bail was recognised as being inherently a matter within the province of the judiciary, and the present appeal is that the fixing of a mandatory penalty for everyone who commits a particular offence is inherently a legislative matter. You see paragraphs 78 above. So that's why Mr. Fitzgerald's whole argument based on Section 1 is in real trouble. The board then goes on to finish off, if I can put it this way, why in paragraphs 94 and 95, Mr. Fitzgerald can't then, as it were, jump from his separation of powers argument to the rule of law argument. And that's at paragraphs 94 to 95. And if I could just ask you briefly to look at that. And my lords, one can well understand that if Mr. Fitzgerald's separation of powers argument is just wrong, because it's for Parliament to fix the penalty, he can't get round that by saying, oh, well, I've got a separate rule of law argument. That, in my submission, is the reasoning in this. And it doesn't help you at all in relation to the effect of Section 1 in a constitution such as this and in a case such as this.
Well, but what do you say about the reasoning at the end of paragraph 94, to which my Lord Sir Rabinder Singh drew attention? Because that's offering separate reasons why one would read whatever is the substantive content of Section 1 narrowly to minimise the overlap with Sections 4 and 5, because otherwise you do produce incoherence, don't you?
In my submission, no, and it's it's not an incoherence, and it's a point that would have knocked out the argument in Mollison. Because in Mollison, my lord, you had exactly the same point. You had a fundamental rights provision which provided for the right to a fair trial and being tried by a court. And that was in the specific provisions. Can I just knock down...
Right, sorry, just before we leave this paragraph, what do you say about the closing part of paragraph 94 and the reasoning there?
What I say about that is that this has to be read in the context that the board is rejecting the rule of law argument. It's not saying that the effect of the savings clause is always to prevent a challenge for some other, if you can properly bring it in relation to some different provision.
Yeah, but the point, well, the point being made at the end of paragraph 94 is that the aspects of the rule of law upon which Mr. Fitzgerald relies are articulated in sections 4 and 5. So it's looking to the fact that the argument was rule of law, section 1, we're not caught by section 6.
Yes.
And in trying to work out where the boundary was for the substantive content of section 1, the board was looking to the sorts of protections you get in sections 4 and 5. And as I read it anyway, we're saying because sections 4 and 5 deal with many aspects of rule of law, and it would be incoherent to say that the regime in sections 4 and 5 is in effect circumvented just by relying on section 1, that's a reason for giving a fairly minimal content to the rule of law idea in section 1 itself.
Well, my lord, I would accept that they are saying that, and I do accept this, you can't just bring any old freedom of expression case and say, right, well, I'm bringing it under section 1. I do accept there has to be a difference, and I accept that much. But I do also say the fact there's an overlap obviously isn't a sufficient answer, because if that was the case, Mollison was wrongly decided. And my lord,
sorry, can I just ask you about that?
Yes.
At paragraph 76 of Chandler, the board explained Mollison, again in terms of the separation of powers principle. So why do you submit that Mollison was wrongly decided if your argument is rejected today?
Because in Mollison there was a specific provision, it was a specific rights provision, my lord, can I just dig up the reference? In Mollison there was a specific provision at, I think it's page 54, at paragraphs F to G, is in our supplementary bundle, which set where there's a specific rights provision. In other words, what was happening was there is a rights provision on which the appellant is relying, but there's a savings clause in relation to that rights provision. And so on the face of it, the Attorney General of the DPP said in Mollison, well, that's it. There can't be any overlap. The matter is dealt with by the fundamental rights provision plus the savings clause.
So the fundamental right provision was, in a nutshell? Is it freedom from arbitrary detention, or what is it?
No, I think it was right to a fair trial, and maybe I think it's, my lord, I can't off the top of my head remember precisely what it was, but it would have been along the lines of that.
As I recall, it's a case about sentencing.
Yes, it was. Yes.
Yeah, well, leave aside questions of a fair trial.
Yes.
If the legislature transfers the power of sentencing from the judiciary to the executive, isn't that a fundamental problem under the separation of powers principle?
Well, my lord, yes, it was indeed. My lord, of course I accept that. I'm just saying that there was a rights provision which on the face of it would have caught the argument. But then you have, of course, the separate point about separation of powers. Now, my lord, in this case, what I say is this. I do not say that it's every breach of the right to freedom of expression and free speech that amounts to a breach of the right to sovereignty, to the sovereign democratic state. We say this. Can I just say in a nutshell why we say the Sedition Act does engage Section 1 of the Constitution? And in a sense, that is the question. Is it sufficiently serious? Because in my submission, it must be common ground that there comes a point when Section 1 is engaged by restrictions on freedom of speech. And the reasons, can I just briefly explain why? First, we are not talking about individual rights. We're here talking about the nature of democracy itself. And I took you to Lang in my original submissions. My lords, also, in the case of Sims, the House of Lords decision in Sims in the late 90s, I think, can I just ask you to look at the following three passages. 2984, first of all. 2984 in Sims.
So just before you move away from your first point, so are you saying that the United Kingdom was not a democracy until 2009?
No, I'm certainly not saying that. But, my lord, its sedition laws did not have the objectionable feature. I do want to develop the fundamental point is not that you can't have a sedition law, but you can't have a sedition law along the lines that was passed in Trinidad. That's the essence of it. But can I just first of all say, I say interferences or substantial interferences with the right to political, and I emphasise political speech, does amount to an infringement of the Section 1 guarantee of a democratic state. It's the political nature of the speech, and that is the great objection to the Act. And what we are saying essentially is this. The Sedition Act strikes at the heart of the democratic process because it puts citizens in peril of a search, criminal prosecution, conviction, and imprisonment for expressing their views in such a way merely as to cause disaffection without any intention to cause violence or public disorder thereby. Now, we say that is of a sufficiently serious nature as to engage Section 1. It's not just any complaint about qualified privilege or various defences of defamation. It's specifically about the political process. So that's why we say you do get into Section 1 by this route. And what we say is this, and if I may, if I go to the Sims decision, 2984, first of all.
You have to be very quick.
Yes, I'm very, very quick. These are just the last references. Yes, yep. 2984, my lord, in Sims. The speech of Lord Stane, the starting point is the right of freedom of expression. In a democracy, it is the primary right. Without an effective rule of law, it is not possible. That's the first point. So I submit, certainly in relation to political speech, it is absolutely essential. And then, my lords, at 2985... 2985, yes. You'll see a reference to the freedom of speech being the lifeblood of democracy. 2985E, freedom of expression is, of course, intrinsically important. Its value for its own sake. It's well recognised as instrumentality is important, It serves a number of broad objectives. First, it promotes self-fulfilment. Secondly, the famous word, the best test of truth is the power of the market, and so forth. Thirdly, freedom of speech is the lifeblood of democracy. And my lords, I say freedom of political speech is the lifeblood of political democracy. And that is why I accept all the points that have been made about you can't just treat all freedom of speech cases as infringing, or legislation is somehow infringing Section 1. The question is one of degree. And my submission is, and this is what the judge at first instance accepted, is that as a matter of degree, this is a very serious infringement indeed. Unless, of course, you read in the requirement for incitement to commit violence and so forth. But that, I submit, my lords, is not possible, for the reasons I've given. And, my lord, my learned friend referred to paragraph 22, at page 82 of the supplementary bundle is the relevant reference.
Sorry, supplementary bundle, what's the right page number?
Page 82. My lord, finally, just Matadinum Puntu. My learned friend took to Matadinum Puntu. My submission, absolutely nothing turns on that. That's quite a different case. That was a case where there was a challenge on the basis of that legislation didn't, I think, in relation to schools, didn't provide for equality in relation to schools. Section 1 was not specifically relied on in that case as giving rise to any independent right. It was simply allied, so to speak, to a complaint under Section 3 of the Constitution, and the relevant passages, and therefore, of course, there was no argument on that point. Can I just ask you to note for a note, page 2507, and then 2515B and 2516B to C. I say matter deemed in front of you is a totally different case and doesn't give you any illumination in relation to these cases.
Mr. Knox, thank you very much. Very grateful to you. Also grateful to Mr. Maharaj and to Mr. Hussain.
My Lord, might I just mention the reference?
Yes, the reference you were going to give us.
Paragraphs 25.
Sorry?
Paragraphs 25 and 26 at our third supplemental bundle, page 45. It's res against the Queen. It's Lord Bingham dealing with the right of the legislature to create offences and to prescribe penalties.
I'm going to ask you to give the reference again, please. The name of the case.
Third supplemental bundle. Well, the case is res, R-E-Y-E-S, against the Queen. It's a judgment of the board.
Yes.
It's that supplemental bundle, third supplemental bundle, pages 45 and 46. And it's at paragraphs 25 and 26.
Thank you.
Thank you very much, my lords.
Thank you. Very grateful to all counsel in the matter, and also to those sitting behind counsel who've played their part in the preparation of the appeal. The board will take time to consider their judgment. The court is now adjourned. Thank you all very much.